Welcome. Good afternoon. I am Robert Strassfeld. I am the director of the Institute for Global Security Law and Policy, which is part of the Frederick K. Cox Center for International Law here at Case Western. And it is my great pleasure to introduce our speaker today, Jameel Jaffer. Jameel is the director of the National Security Project of the ACLU, a graduate of Williams College, Cambridge University, and a classmate of my colleague Jesse Hill at Harvard Law School. You all know the curse about living in interesting times. Jameel has had the opportunity to be the director of the National Security Project in interesting times, and his litigation portfolio has included such matters as a challenge to national security letters, a challenge to the NSA warrantless surveillance, representation of a person who had been extraordinarily rendered to Afghanistan, mistakenly, a challenge to the ideological denial of visas to scholars, and litigation to obtain documents relating to the treatment of detainees in Guantanamo, Iraq, Afghanistan, and elsewhere. And his talk today grows out of that work in particular. He will be talking about Torture, A History of the Present. I'm curious to know what that title means exactly, and I'm about to find out. And without further ado, Jameel.
Thanks, and I guess I should start by thanking Bob and Jesse and Alice Simon for inviting me. In April of 1942, President Roosevelt ordered 80 airmen to launch a surprise attack on Japan in response to the attack on Pearl Harbor. Of the 80 men who participated in the raid, 3 were killed during the mission, 5 were imprisoned in Russia, and 8 were taken prisoner by the Japanese. The 8 American soldiers who were imprisoned by the Japanese were kept mainly in solitary confinement, and they were treated to the most brutal kinds of interrogation. One of the 8 men died in captivity. 3 others were executed by firing squad. Of the 4 men who survived detention by the Japanese, one was Lieutenant Charles Nielsen. He was rescued by paratroopers about 40 months after his capture, and the U.S. and other Allied powers eventually prosecuted Nielsen's captors for war crimes. Nielsen testified that during his captivity he'd been subjected to something that he called the water cure. He said that the treatment had made him feel like he was drowning, like he was gasping between life and death. Ultimately, several members of the Imperial Japanese Army were prosecuted and convicted of war crimes. Some of them were sentenced to up to 15 years in prison. In recent years, the same methods that the U.S. once prosecuted as war crimes have been endorsed as U.S. policy. The CIA has subjected dozens of prisoners to so-called enhanced interrogation methods. Both CIA and military interrogators have confined prisoners in stress positions, stripped them naked, subjected them to extreme temperatures, deprived them of sleep for up to 40 hours at a time. On at least 3 prisoners, the CIA has used the same methods that the Imperial Japanese Army used on Lieutenant Charles Nielsen. CIA interrogators immersed the prisoners in water to make them believe that they were drowning. And all of that was done with the approval of the country's most senior officials. The Attorney General was recently asked whether CIA agents who had waterboarded prisoners could be prosecuted for it, and Attorney General Mukasey's answer, a forthright answer, I think, was that they couldn't be prosecuted, wouldn't be prosecuted, because they had acted with the approval of Justice Department lawyers. Contemporary discussions of torture tend to focus on the present, on the moment in history that the U.S. occupies right now. But to understand where we are right now, it can help to understand where we've been and how we got from there to here. And specifically, how did the U.S. come to authorize interrogation methods that it once recognized as war crimes? And how did the political language change so that tactics that we once called torture are now called enhanced interrogation methods? And how did this happen within the space of just a few years? So I want to identify some key facts that will help sketch a history of the present. I won't try to untangle everything, all of the many things that have been said about torture and interrogation in recent years. For example, I'm not going to talk about rhetorical strategies that people sometimes use to defend torture, the most prominent of those being the ticking bomb hypothetical. We can discuss that later on if you want, but I'm not going to mention it in my prepared remarks. Instead, I want to leave hypotheticals to the side and focus on the facts, on factual information that we have about the U.S. government and its treatment of prisoners over the last few years. There's actually quite a lot of information that's available, quite a lot of factual information. There should be even more information, but the Bush administration continues to withhold some critical documents. But at the ACLU, we've been gathering and distilling information about the treatment of prisoners, and I think we've learned quite a lot. What we know primarily from the government's own documents, documents they didn't necessarily want to give us, but they're documents that the public has a right to, and they're documents that we've been able to obtain. So back to my original question, what just happened? How did torture come to be called enhanced interrogation? How did the same methods that the U.S. treated as war crimes 60 years ago come to be used by government personnel? And this particular history, I think, can be divided into 6 chapters. They're short chapters. Specifically, 6 decisions by high-ranking officials in the Bush administration. There are 6 of those decisions that I think can fairly be said to have contributed either directly or indirectly, mostly directly, to the torture of prisoners. What I want to emphasize before I go through those 6 decisions, those 6 chapters, is that each of them contains a decision made by senior officials, a specific choice by the administration or by particular officials within it. When we ask ourselves what just happened, it's important to remember that the torture didn't just happen in the sense of it took place by accident or unpredictably or unexpectedly. There are at least 6 critical decisions that have led us to the present. So let me identify those decisions, and then if you have questions, I'm happy to take them. Chapter 1, the December 2001 decision to hold prisoners at Guantanamo Bay. After the war in Afghanistan began in October of 2001, lawyers in the Justice Department were asked to consider whether prisoners held at Guantanamo Bay would have access to the U.S. courts. And the concern, as expressed by lawyers in the Office of Legal Counsel, was that prisoners who had access to the courts would be able to challenge the legality of their detention, the legality of their treatment, and possibly even the legality of the military commissions. In a December 2001 memo, the Office of Legal Counsel concluded that prisoners held at Guantanamo would not have those rights, that prisoners held there would be beyond the reach of the law. Now, that memo was issued on December 28, 2001, and the Defense Department began delivering prisoners to Guantanamo 2 weeks later. Since then, the Supreme Court has rejected the administration's theory that Guantanamo is an island without law. The court held in 2004 that prisoners held at Guantanamo did, after all, have the right to challenge their detention in court. Congress has since amended the habeas statute in an effort to quash the prisoners' petitions. But most observers, I think, agree that the Supreme Court is likely to hold later this year that the prisoners' right to challenge their detention is rooted in the Constitution, and so Congress can't change it. So that's Chapter 1, the December 2001 decision to hold prisoners at Guantanamo Bay. Chapter 2, the February 2002 decision to deny Taliban and Al-Qaeda prisoners the protection of the Geneva Conventions. The administration chose Guantanamo because it believed that prisoners held there wouldn't have access to lawyers, wouldn't have access to the courts. But the administration's lawyers knew that they might lose that argument. To say this another way, the administration's lawyers knew that they might lose the jurisdictional argument, but they still wanted to win on the merits. So they immediately began to consider legal strategies to defeat the substantive arguments that the prisoners were likely to make. In early 2002, the Office of Legal Counsel produced a memo interpreting the U.S. War Crimes Act. That's a statute that criminalizes some violations of the Geneva Conventions. The memo concluded that the prisoners held at Guantanamo weren't entitled to the protection of the Geneva Conventions at all. The Taliban weren't entitled to protection because Afghanistan was a failed state. And Al-Qaeda detainees weren't entitled to the protection because Al-Qaeda wasn't a state at all, but merely a violent political movement. And according to the memo, the prisoners weren't entitled even to the protections of Common Article 3, an article that would otherwise have protected prisoners from violence to life and person, cruel treatment and torture, and humiliating and degrading treatment. Now, Common Article 3 is actually supposed to protect everybody. It doesn't matter if you're wearing a uniform. It doesn't matter if you're a prisoner of war. It doesn't even matter if you've been charged with a war crime. Common Article 3 is supposed to protect you. It's supposed to protect you against cruel treatment. But the administration concluded that it didn't protect the prisoners held at Guantanamo. Now, those conclusions were controversial even within the administration. But Alberto Gonzales, who was then the White House counsel, endorsed all of them. Gonzales wrote a now infamous memo that advised the president that the war on terror had rendered obsolete the Geneva Convention's strict limitations on the interrogation of prisoners. And he recommended that the president deny the prisoners the protection of the Geneva Conventions in order to preserve flexibility and reduce the threat, that's his quote, that interrogators and officials would be prosecuted for war crimes. President Bush formally endorsed Gonzales' recommendations on February 7, 2002. And in an order made public that day, the president said that the war on terror had, quote, ushered in a new paradigm. The administration's position on the Geneva Conventions, like its position on habeas, has been rejected by the Supreme Court. The court held in 2006 that prisoners held at Guantanamo were entitled at least to the protections of Common Article 3. It held, in other words, that prisoners could not be subjected to cruel treatment. I said earlier that the Bush administration found that that prisoners held at Guantanamo weren't entitled to the protections of Common Article 3. The consequence of the Supreme Court's ruling is to hold that the kinds of treatment that the prisoners were subjected to in 2002 and 2003 constituted war crimes. The Supreme Court doesn't actually say that in its decision, but it implies it, and it's the logical consequence of the decision. In 2002, the administration adopted certain methods on the basis of its conclusion that prisoners were not entitled to Common Article 3 protection. It turns out that the prisoners were entitled to Common Article 3 protection. The consequence of that legally is that what took place at Guantanamo constituted war crimes. So, Chapter 1, the December 2001 decision to hold prisoners at Guantanamo Bay. Chapter 2, the February 2002 decision to deny Taliban and Al-Qaeda prisoners the protection of the Geneva Convention. Chapter 3, the August 2002 decision to supply the CIA with a legal basis for torture. While the Defense Department was delivering prisoners to Guantanamo, the CIA was holding a smaller number of prisoners, high-value detainees, it called them, in secret detention facilities all over the world. Like the Defense Department, the CIA wanted to know what the president's new paradigm actually meant in practice. It wanted to know what kinds of interrogation methods it could use against the prisoners held in its custody. The Office of Legal Counsel had already opined that Al-Qaeda prisoners weren't protected by the Geneva Conventions or the War Crimes Statute. But there were other possible constraints on the interrogation methods that could be used. For example, there was the Convention Against Torture, which the U.S. signed in 1988 and ratified in 1994. And there was the U.S. Torture Statute, which implements the Convention Against Torture by criminalizing torture. In August 2002, the Office of Legal Counsel issued a memorandum interpreting the Convention and the Torture Statute. The memo contended that an act doesn't rise to the level of torture unless it inflicts pain, and now I'm quoting from the memo, equivalent in intensity to the pain accompanying serious physical injury, such as organ failure, impairment of bodily function, or even death. The memo contended that even if the torture statute barred a particular interrogation method, the President had the authority under the Commander-in-Chief Clause of the Constitution to ignore that statute. Now, if that sounds familiar, it's because the administration has used exactly the same argument to justify other national security policies, including the National Security Agency's warrantless wiretapping program. It was that August 2002 memo that allowed the CIA to adopt waterboarding as an interrogation method. As absurd as it may sound, the administration's argument was that waterboarding doesn't cause the same kind of pain that organ failure does, and so waterboarding isn't torture. That was the argument. The August 2002 memo was eventually leaked to the press, and the administration decided to rescind it rather than defend it. But the administration stood by its determination that the enhanced interrogation methods, including waterboarding, didn't rise to the level of torture under U.S. law. In 2005, after the Supreme Court held that prisoners were entitled to the protections of Common Article 3, that prisoners couldn't be treated to cruel treatment, the Office of Legal Counsel found that the enhanced interrogation methods did not constitute cruel treatment either. It had previously found that the enhanced interrogation methods weren't torture. Now it found that the enhanced interrogation methods, including waterboarding, weren't cruel treatment either. So the administration's lawyers just redefined cruel treatment. They redefined cruel treatment in the same way that they had redefined torture 3 years earlier. Chapter 4, the December 2002 decision to authorize coercive interrogation methods at Guantanamo. The President's decision to deny Geneva Convention protection to the prisoners held at Guantanamo was meant to allow the use of interrogation methods that would otherwise have been considered war crimes. But it didn't actually authorize anything at all. The President allowed the use of the methods, but he didn't authorize them. Instead, President Bush ordered the prisoners should be treated in accordance with the Geneva Conventions, but only to the extent appropriate and consistent with military necessity. It was left to others, at least in the first instance, to sort out what that meant. So think of it like this. President Bush opened a door, but he didn't walk through it. He then turned to Secretary Rumsfeld and he said, "After you." And Secretary Rumsfeld walked through it. In December of 2002, Secretary Rumsfeld issued an interrogation directive at Guantanamo that authorized interrogators to isolate prisoners for 30 days at a time, deprive them of light and auditory stimuli, strip them naked, hold them in stress positions, and terrorize them with military dogs. The directive was predicated on the President's decision to deny prisoners the protection of the Geneva Conventions. Now, I think phrases like stress positions and deprivation of light and auditory stimuli are clinical phrases, and they don't convey that much in themselves. But we actually have access to thousands of documents, government documents, that fill out our understanding of how those interrogation methods were used and what their consequences were. One of the documents we obtained through the Freedom of Information Act is an FBI letter to the Defense Department. FBI agents were stationed at Guantanamo in 2002, and they initially participated in some interrogations that were run by the military. After that, they stopped participating, but they still witnessed some of the interrogations. And sometimes they just encountered prisoners after they'd been interrogated by the military interrogators. So this is what the FBI's letter says. FBI agents observed a detainee after he had been subjected to intense isolation for over 3 months. During that time period, the detainee was totally isolated, with the exception of occasional interrogations, in a cell that was always flooded with light. By late November, the detainee was evidencing behavior consistent with extreme psychological trauma, talking to non-existent people, reporting hearing voices, and crouching in a corner of the cell covered with a sheet, for hours on end. So, it may be true that the methods approved by Secretary Rumsfeld in December 2002 didn't cause the kind of pain usually associated with organ failure or even death. But the methods were sufficient to drive some of the prisoners literally out of their mind. Chapter 5, the decision to supply the Defense Department with a legal basis for torture. Rumsfeld's 2002 interrogation directive came under fire as soon as it was issued. FBI agents complained about it. They said that the interrogation methods were ineffective, illegal, and abusive. And some military personnel, including the Navy's General Counsel, said exactly the same thing. So in January 2003, Rumsfeld rescinded the directive, and he convened a working group to reconsider the interrogation methods that could be used against prisoners at Guantanamo. Now, that may seem like a reasonable course of action, but there was a catch. Rather than let the working group reach its own conclusions, the Office of Legal Counsel provided the working group with a legal memo written by John Yoo that parroted the reasoning of the organ failure memo that had earlier been given to the CIA. Like the earlier memo, the John Yoo memo argued that there were literally no limits on the kinds of interrogation methods that could be used, and the working group was required to accept John Yoo's memo as definitive. So once the working group was told to do that, it was a foregone conclusion that it would approve abusive methods, and that's exactly what happened. The working group endorsed a long list of abusive methods, including extended isolation and environmental manipulation. Rumsfeld didn't approve all of those methods, but he approved some of them, and he looked the other way when interrogators used methods that he hadn't approved. So some abusive methods were approved, and other methods were tolerated. Chapter 6, the decision to Gitmoize Abu Ghraib. Major General Jeffrey Miller became the commanding general at Guantanamo in late November of 2002. He was the commanding general when Rumsfeld issued his interrogation directives. He was the commanding general when Rumsfeld convened the working group. He was the commanding general when prisoners were stripped naked, hooded, confined in stress positions, and threatened with military dogs. Sometime in the summer of 2003, Rumsfeld and other senior officials decided that the detention centers in Iraq should be modeled after Guantanamo. And so they gave Miller a copy of the working group report, the one that was based on John Yoo's memo, and they sent Miller to Iraq to Gitmoize Abu Ghraib. And this strategy worked. In September and October of 2003, Miller convinced Lieutenant General Ricardo Sanchez, who was the highest-ranking military official in Iraq, to issue interrogation directives that were modeled on the ones that Rumsfeld had issued at Guantanamo. And the abuses at Abu Ghraib, the ones that you've all seen photos of, followed soon after that. When those photos became public in 2004, most of us, I think, were shocked by what we saw. We would have been less shocked had we known about everything that had preceded those photographs. The president said that the photos showed rogue soldiers, a few bad apples. But in fact, the photos showed military personnel using methods that had actually been approved. Remember, some of them showed naked prisoners, some of them showed hooded prisoners, some of them showed prisoners shackled to railings in stress positions, some of them showed prisoners being threatened with military dogs. All of those methods had been approved, either by Rumsfeld at Guantanamo or Lieutenant General Sanchez in Iraq, or both. If there was anything surprising about the photos, it wasn't the interrogation methods that were being used, it was the fact that the methods were being used by military police rather than military interrogators. But the principal innovation at Guantanamo was to integrate detention and interrogation, to blur the line between military police and military interrogators. In General Miller's words, the principal innovation at Guantanamo was to insist that military personnel in charge of detention, quote, set the conditions for interrogation. Once you understand that, it's not surprising anymore that the photos showed military police using approved interrogation methods. That's what the military police were told to do, set the conditions for interrogation. So 6 decisions that contributed directly or indirectly to the torture of prisoners in U.S. custody. The December 2001 decision to hold prisoners at Guantanamo Bay, the February 2002 decision to deny Taliban and al-Qaeda prisoners the protection of the Geneva Conventions, the August 2002 decision to supply the CIA with a legal basis for torture, the December 2002 decision to authorize coercive interrogation methods at Guantanamo, the decision to supply the Defense Department with a legal basis for torture, and finally, the decision to Gitmoize Abu Ghraib. I don't want to say much more than that, but I want to make one somewhat peripheral observation before I close. Some of you may have seen that 10 days ago, about 10 days ago, the government released a copy of the John Yoo torture memo, the one that supplied the Defense Department with a legal basis for torture. Since the memo was released, the question in the newspapers and on the blogs has been whether John Yoo should be held accountable in some way. Some law professors have suggested that John Yoo should be indicted for war crimes. And there's an organization called American Freedom that has started a campaign to get John Yoo fired from his post at Bolt Law School at Berkeley. But Professor Yoo has now defended himself, and this is what he said. He's told us to the New York Times. He said that all he did was provide legal advice. He didn't authorize anything. I think it's interesting to juxtapose that defense with what Attorney General Mukasey told Congress a few weeks ago. The Attorney General, remember, said that CIA agents couldn't be held responsible because they'd been relying on legal advice. And now it turns out, perhaps unsurprisingly, that the people who gave the legal advice don't think that they should be held responsible either. Those who actually carried out the torture claim immunity on the grounds that they were listening to lawyers. But the lawyers claim immunity on the grounds that the torture was carried out by others. So the CIA points fingers at the Justice Department, and the Justice Department points fingers at the CIA. Now, the ironic thing is that the people who've been asking us to draw these fine distinctions between executive agencies, between the Justice Department that gave advice and the CIA that implemented it, are the same ones who were once waving flags for what was called the unitary executive. We needed a unitary executive to fight the war on terror, that's what they said, so that the government could speak with one voice and act decisively. We needed a unitary executive so that citizens would know who to hold accountable if things went wrong. So here's my peripheral observation. It turns out that the executive is unitary only when it comes to exercising power. When it comes to taking responsibility, the executive is not unitary but multifarious. When it comes to taking responsibility, it's every man for himself. Thanks.
Thank you. We have time for questions. We are webcasting, which means that people who are viewing from a distance need you to use the microphone when you ask your question. So please wait till the microphone appears before asking. I'll let you fill our folks in.
How about up front here?
Something sounds like the German judges in the 30s approving all of Hitler's, stamping with judicial approval, the laws that stripped the Jews of their property and their money and all their assets, and then ultimately confined them. What's the difference?
Well, I'm not sure that it's. I'm not sure it's productive to compare the two crimes, but it is certainly true that the lawyers' involvement in torture here was something more than the involvement of lawyers in giving ordinary legal advice. The lawyers, John Yoo and the other lawyers in the Office of Legal Counsel, they weren't simply giving legal advice here. They were giving legal advice with a specific end in mind. The legal advice, I think it's almost universally agreed now. The legal advice was unprofessional, that it didn't meet even professional standards in terms of the kinds of research they provided, the kinds of legal reasoning they engaged in. There are, I mean, just to give you one example, the argument that the president has the authority to ignore the torture statute, or that the president has authority under the Commander-in-Chief Clause to ignore statutory law more generally. That argument has actually been rejected by the Supreme Court. It was rejected in a case called Youngstown Steel in the 1950s. It was a Korean War case. But that case is nowhere cited in John Yoo's memo. It just doesn't even appear. But I think that if you submitted this kind of you submit this kind of memo in response to a law school assignment, you wouldn't do very well. It did. But I also think that John Yoo did something worse than just give bad legal advice. When the Office of Legal Counsel was approached in 2003 to provide this memo to the Defense Department, prisoners had already been tortured by the CIA. Prisoners were already being abused and in some cases tortured by the military. And what they were asking for was not a memo to authorize future interrogation methods. That was part of it. But part of it was a memo. They wanted a memo to ratify what had gone before. And what had gone before included 2 prisoners having been beat to death in military custody in Afghanistan, a whole slew of prisoners who were abused, sometimes quite brutally at Guantanamo. And the lawyers at the Office of Legal Counsel knew that all of that had gone on when they were asked to write this memo. And they nonetheless wrote this memo. So I know this isn't really an answer to your question, but in the end, I think that that the Office of Legal Counsel has to be held responsible for something more than giving bad legal advice. I don't think that's all they did. Yeah, right in the middle there.
I heard that Mr. Yoo was the assistant attorney general, that he was acting qua assistant attorney general, and he wasn't just giving unsolicited legal advice as a member of a law school. So if this is the case, would that fact weigh into people having standing in a court of law to make him answer for that memo?
Well, he was part of the Justice Department when he gave that advice. He was, I think his title was Deputy Assistant Attorney General in the Office of Legal Counsel. And that's relevant insofar as it was because of the fact that he had that position, that people were listening to his advice. Ultimately, if he had written this kind of memo as a law professor, if he'd written a law review article that made the same arguments, I think that accountability would have consisted of other articles written by other professors that pointed out all the flaws in his reasoning. The reason that people are asking for something more than that kind of accountability is that his legal advice had real consequences in the real world. I think it's actually a complicated question to what extent somebody like John Yoo can or should be held responsible for the torture of prisoners that happened as the result of the legal reasoning he engaged in. It's a complicated question because we want lawyers to feel free, lawyers in the government to feel free to give legal advice to the president. We want them to be able to interpret the law broadly and then tell the president that he can choose to act more narrowly if he wants to. We want all those things to be possible. There are some differences, though. I mean, again, I think that John Yoo did something more than that. I think that not just you, but the other lawyers in the Office of Legal Counsel as well, they weren't just giving bad legal advice. They gave bad legal advice that resulted in torture and that they knew would result in torture. And I think that makes their situation different from the situation of a lawyer who just writes a bad memo. How about up front, if that's easier?
You quoted the term pain of organ failure and death several times. It's a curious phrase because medically, organ failure hardly ever is associated with pain. Chronic lung, kidney, liver, even brain is hardly ever associated with pain. I don't know at the moment of death whether that's painful, but most people would say it probably is not painful. What is very painful is acute ischemia to the brain, the heart attack, lung, pulmonary embolus, or the intestines, but that hardly ever causes organ failure. Where does this come from?
You know, it's a phrase that was actually borrowed from an interpretation of a different statute. That it comes from a different context altogether, and I don't remember. It has something to do with a healthcare statute, completely unrelated. And the reason that Jay Bybee and John Yoo plucked that phrase from those court cases is because they were trying to come up with an interpretation of the phrase severe pain, which comes up in the torture statute. The torture statute prohibits torture, and torture is defined to be anything that causes severe physical pain, severe physical or mental pain. And so in order to define that phrase, Professor Yoo and now Judge Bybee looked to case law that had used that phrase in completely different contexts, and they pulled that phrase into this context. It's just as a matter of statutory interpretation, I think that a lot of people are dubious that the right way to interpret the torture statute is to pull interpretations of healthcare statutes. They come from different contexts. Again, I think that bad statutory interpretation might be excusable if it were just bad statutory interpretation, but it was bad statutory interpretation to an end, and the end is what's problematic.
I have a question, but I'd like to first respond to the first questioner about the judges in Germany in the 1930s who upheld a whole series of National Socialist legislation, much of which was to very ill effect. The short answer is they all got their jobs back in 1949 and populated the West German judiciary until retirement or until some scandals began to arise really in the 1960s. So the answer was they had a rough time from 1945 to 49, but after that, not much. I know you're deeply involved in the litigation, and I think all of us are there in some ways, but I'm taken with a little larger perspective here. There's another episode in my lifetime of massive bad behavior by government lawyers that resulted in a public outcry that actually had consequences in legal education. And this is the bad behavior of the lawyers in the Nixon administration. John Dean, but Donald Segretti, and all those other guys. And there was great amazement that lawyers would sit down and talk about doing things they knew were illegal, structuring arguments to give them colorable legality, and then proceeding to do them. I entered law school as the first class that was required to take the mandatory professional responsibility class, which was the ABA's response to that. This administration has made it clear what it thinks of the ABA, not to mention the ACLU. But what do you think is the likelihood of the legal profession itself making some sort of statement or an effort to deal with this intentionally outcome-oriented lawyering that seems profoundly to have infected not just the Office of Legal Counsel, but the Justice Department broadly?
I think it's only now starting to happen that the legal community is struggling with its own responsibility for what happened. I've seen a lot more of it in the last 10 days since that U memo was released.
I actually have it on my screen.
All right. Maybe you can tell us what statute they were referring to when they pulled that phrase.
I quote a professor from med school here on immigration law, treatise that she wrote.
But just to go to your first point about the responsibility that accountability for Germans. Well, the people who have been most involved in approving torture, endorsing torture, the people who should have been held accountable for their decisions have actually not been held accountable. Most of them have been nominated and confirmed to higher posts, right? John Yoo has a professorship at the University of California at Berkeley. Jay Bybee, who wrote the first torture memo, or signed the first torture memo, is a federal judge. William Haynes, who was the general counsel of the Defense Department, is still general counsel. He was nominated to be to the federal bench, but didn't get approved, didn't get confirmed. I think they withdrew his name. But he's still general counsel. And although Alberto Gonzales and Secretary Rumsfeld were ultimately resigned, they didn't resign for anything having to do with the torture of prisoners. Paul Wolfowitz became the president of the World Bank, and he was in the Defense Department at the time. He actually signed off on the December 2002 interrogation directive that Rumsfeld issued. So, I think that without exception, the people who should have been held accountable have been rewarded instead. I did note with some interest that there's a small article in the New York Times a couple of days ago that said that Alberto Gonzales was having trouble getting a job. Maybe that's a start. Yes.
You mentioned that we already have the anti-torture statute and we already have the war crime statute in the U.S. Code. My question is, what's the solution to prevent torture? Do we need another statute, or is the solution going to have to come from the judicial branch, or is it going to have to come from the executive branch? I mean, is there any thoughts on how we can prevent torture?
Yeah, I mean, torture is already prohibited. We don't need another statute. The statute is already there. There are two problems. First, the argument that the administration has made in this context and so many other contexts, that the president has authority as commander-in-chief to violate statutory law. Once you adopt that argument, it doesn't matter how many statutes you have, the president believes he has the authority to violate them. And that's, again, the argument that the president made with respect to the torture statute, and it's the argument that the president made with respect to the Foreign Intelligence Surveillance Act when he authorized the National Security Agency's warrantless wiretapping program. So, once you accept that argument, then statutory law is completely irrelevant. So that just leaves, that takes Congress out of the equation, and then the only thing left is the courts. Some of these torture cases have been brought to court. We filed a couple of cases involving the rendition program, the CIA's rendition program. There have been a number of cases filed against senior officials for their approval of torture. But in each of those cases, or most of those cases, the administration has invoked something called the state secrets privilege, which is a privilege that used to be thought of as an evidentiary privilege, meaning that the government could invoke it with respect to a specific piece of evidence. If you sued the government and you said, I'm suing you because you tortured me, the government could say, well, if you need a specific piece of evidence, you say, I don't know, you need a copy of the blueprint for Abu Ghraib. The government might be able to come back and say, we can't give you that specific piece of evidence because to give you that evidence would disclose national security secrets. That used to be the state secrets privilege. But now the administration has been using the state secrets privilege to shut down litigation altogether. They don't deny you access to a specific piece of evidence. Instead, they say, we can't litigate this case at all because litigating the case would disclose national security secrets. Now, you may ask, well, what's secret about torture? The administration has been saying to everybody that it has been waterboarding prisoners. It's been saying to everybody it's been rendering prisoners to other countries known and expected to use torture. But the administration has nonetheless been saying to federal courts that even if everybody else can discuss torture, even if the European Union can issue reports about the U.S.'s involvement in torture, even if Canada can pay $10 million to somebody as compensation for having been tortured as a result of the rendition program, even if all of those things are happening, we can't discuss torture in a federal courtroom. To discuss torture in a federal courtroom would jeopardize national security. That's the administration's position. And as absurd as it may sound, that position has prevailed in all of the torture cases in which the government has invoked the privilege. So that takes the courts out of the equation as well. So I think that there are, there are two solutions. One is we have an administration that abandons the view that the president has the authority to violate the law. I think that would be great. Another possibility is that the courts strike down or narrow the state secrets privilege. And over the last few years, the ACLU and a bunch of other public interest organizations, the Center for Constitutional Rights, have been arguing that the court should narrow the state secrets privilege. And I think most legal observers think that eventually, sometime in the next couple of years, the Supreme Court is going to have to take one of these state secrets cases and decide whether we're going to give the executive branch, we're going to give officials who are accused of things like torture the ability to shut down litigation that would hold them accountable.
You mentioned earlier that had John Yu's article or memo been submitted into the law school, he wouldn't have done very well. Is it possible in the future, before such a memo is submitted, that just to kind of piggyback off the gentleman to the right, is there enough parameters in place at the Department of Justice before such a memo of that magnitude is submitted to cite more statutes that he may have left out before giving it to the White House ultimately to make their decision?
Well, I didn't mean to suggest that it was a matter of just John Yu writing a memo that failed to cite the right cases. John Yu's memo must have been read by a dozen lawyers in the Office of Legal Counsel. The decision not to cite Youngstown Steel was not an inadvertent one. I mean, they decided not to cite that case. And I think that the problem, sometimes people call the Office of Legal Counsel the conscience of the executive branch. And the problem is that ultimately you have to depend on the integrity of the individuals who are in an office like that. If the people in that office want to create memos like the John Yu memo or the Jay Bybee memo, in the end there's very little that the rest of us can do about it. You just have to hope that the people who are in those positions have some degree of integrity, not just professional integrity, but moral integrity as well. And I think that there's the feeling that this administration at the very top has been lacking that kind of integrity, and I hope that maybe the next administration won't be. Yeah. Right at the back. There. Last row.
Then were some of the other pieces left out, things like in 1902 and 1903, when a military judge declared waterboarding a capital crime in the hands of the military? Or when in 1926 the Mississippi Supreme Court called it a crime? Has that ever been discussed? Or where we got the term enhanced interrogation techniques? I have read that it was presented to us by the Gestapo. Has that been discussed?
There are still two very significant memos that haven't been released. One of them is the one that actually approves the interrogation methods that the CIA characterizes as enhanced interrogation methods. That's a memo that was written in August of 2002. We've been trying to get it through litigation. The administration refuses to release it. I think that ultimately it'll come out, and I think part of the reason that the administration is refusing to release it is because they will never be able to explain that memo given the kinds of facts that you are pointing to. How can they explain a memo that says to the CIA, you can waterboard prisoners, you can hold prisoners' heads underwater until they feel like they're about to die? How can they explain a memo like that, given the history, even in this country, and in the courts of this country, of characterizing those kinds of techniques, and that technique in particular, as torture and as a crime? I think that's why they won't release it. And
what do we do in the meantime besides hope?
Well, we litigate. I don't know. Our Washington Legislative Office actually just put out a statement yesterday. It's a statement we've put out before on half a dozen occasions to little effect, calling for an independent prosecutor to look into the torture of prisoners. There is, I think that it's getting a little more traction this time around. I think that the John Yoo memo has somehow put some people over the edge. I still doubt that, well, I'm sure it will not happen during this administration. Who knows what will happen during the next one.
Apart from being unlawful and morally repugnant, from what I understand, torture isn't even an effective means of obtaining accurate information. So I guess my big question is, why?
Yeah, you know, one of the things, so in the course of this Freedom of Information Act litigation, we've been getting, all kinds of documents from the Defense Department and the Justice Department. But one of the most interesting sets of documents that we got is from the FBI. And the FBI gave us all of these documents created by FBI agents who were at Guantanamo in late 2002 and early 2003. And these FBI agents witnessed interrogations conducted by military interrogators who were using the techniques that Secretary Rumsfeld had approved. And I read you one letter. But there are a lot of FBI memos and emails that complain about the effectiveness of those methods. And not only do they complain that the methods produce information that's unreliable, they actually complain in some instances that there were prisoners who were cooperating with them, people who were giving them information, who stopped cooperating once the Defense Department started using those methods. So it's not just that they were ineffective, they were counterproductive. And for us, I was saying this to somebody else earlier, but it's one thing for an ACLU lawyer to go out there and say torture is ineffective. Nobody listens to us. But when we have the FBI documents, FBI agents who, interrogate people as a profession, they're saying that this stuff is not effective. That actually means something to people. And, I'll make a pitch for a book that we just recently published. We recently collected some of those documents, including the FBI documents, in a book. It's called Administration of Torture, and it was published by Columbia University Press. But we have about 50 pages of FBI emails and memos discussing the effectiveness or ineffectiveness of the methods that the military approved.
Jameel? I think I heard you say in passing that your prediction is that the Supreme Court's going to uphold detainees' rights to access habeas in the cases that are for it again this term. I just wanted to hear more about that prediction, why you thought that's the case.
Well, okay, just a little background for people who don't know about this case. So in 2004, the Supreme Court held that prisoners held at Guantanamo Bay have the right to challenge their detention in court. But the Supreme Court's decision was predicated on a statute, on the habeas statute. After the Supreme Court made that decision, Congress amended the habeas statute, narrowed it so that prisoners at Guantanamo Bay could no longer rely on the habeas statute to argue that they were entitled to challenge their detention in court. But the prisoners nonetheless went back to court and they said, look, we don't need the habeas statute because we have the right under the Constitution to challenge our detention in court. The Constitution says that habeas, the right to habeas, can be suspended only in times of rebellion or invasion, and this is not one of those times. Nobody has declared it to be one of those times, and so we have the right under the Constitution to challenge our detention. And the administration argued that the constitutional right doesn't extend to prisoners held at Guantanamo Bay, that to the extent that they had a right to challenge their detention, it was based solely on the statute. Once the statute disappeared, their right to challenge their detention disappeared. And as to the language in the Constitution that says the habeas right can only be suspended in these circumstances, the administration argued, well, that just tells you when the habeas right can be suspended. It doesn't tell you whether it existed in the first place. But I think that a lot of people initially thought that the administration would have a pretty good chance of winning before the Supreme Court, both because the Supreme Court is quite conservative now, but also because the administration thus far has been rebuffed 3 times by the Supreme Court in these detention cases. And people just thought that, sooner or later the Supreme Court is just going to feel like, we've had our say and it's time to defer to the executive. But the oral argument, I wasn't at the oral argument, but my understanding from people who were at the oral argument is that the justices, including Justice Kennedy, who is the one who really has a swing vote, were dismissive of the administration's habeas argument, and that all the action is not around whether the prisoners have the right to challenge their detention, but whether the process that they've been provided at Guantanamo is an adequate substitute for habeas. So the prisoners have this process called the Combatant Status Review Tribunals. They can challenge their detention in that context before military personnel. They don't have lawyers. They're not given lawyers. They're not given access to the evidence against them. Coerced evidence can be used against them. Hearsay can be used against them, but there is nonetheless a process. And the administration's argument, its backup argument was, look, even if they have the right to habeas, even if they have the right to challenge their detention, we've given them process that is an adequate substitute for that right. So just based on the oral argument, it sounds like that's where the court's attention is. And I don't think nobody's making predictions about whether the court is going to find that this is an adequate process or not. But I think that there is widespread agreement that the most likely outcome is that the administration loses the first argument, at least, the habeas argument.
This will have to be the last question.
Okay, I'm kind of looking ahead a couple of years and wondering, in view of all of these acts that were basically authorized by political people in the administration, when that administration leaves office, what is the likelihood of them being held accountable, or say an international court coming after American politicians for authorizing a lot of these acts against citizens from other countries?
I think that if I were Secretary Rumsfeld or Attorney General Gonzalez, I would not do a lot of international travel because, yeah, I don't think that criminal accountability is likely in the U.S. Not because they aren't guilty of war crimes. I think they are, but I just think politically it's not going to happen. I think it's much more likely that a prosecutor with universal jurisdiction outside the U.S. Would try to prosecute one or more of the officials who endorsed torture, but they can't do that unless the official steps foot in their territory.
Two things. One, I need to grab. Or thank you, besides all our other thank yous, to, just in terms of applause. It is a very large thermos. But, I mean, it's a very classy, very large thermos. Suitable for very, very long depositions. And second of all, I would just like to invite all of you to join us. There's a reception, I assume, upstairs. It's an opportunity to continue the conversation. And thank you very much for coming out.